today. That was the final salary that was offered to the HR manager. Subsequent to that, there was a settlement with the union and the government. There was a 3-year increase. So that would have applied for 17-18 and a part of 18-19. So it's 9 and 5. So those percentages would have been added to the second letter, and then that is what was used to calculate the settlement.
The 9%. When did the 9% become effective? What was the effective date of the firm?
It's April to March 18.
No.
17.
No. April 1, 2017
to March 2018. That's
right.
the first.
So having been employed under a letter dated January the 30th, at a total compensation package of just over 10 million.
Right.
Subsequently, that was replaced by a letter backdated to the same date, January the 20th, 2017, with a higher gross figure, which was the definitive figure at that time of 12.977 million. And then effective, and this was in, say, February, I think it took effect February 14th, 2017. Then as of April 1, 2017, she got a 9% increase.
Retroactively, yes.
Retroactively to April 1, and then she got another 5% increase a year later.
The following year.
And that is compounded.
Yeah, man. The what? No, ours is 3.
Yeah, they're not governed by it. Yes. That's why it was 9.
Petrojam was 3 years.
Yeah, and it was 9%.
9 in the first year, 5 in the second year, and the third year would have been 4.
Your contract ended 2017, March. So the 9 would have become effective April 1, 2017.
Correct.
Right. To March 2018.
March 31st, 2018, which is the, and then the other 5 would have been 2018 March.
No.
April 1, 2018 to
March 2019.
To March 2019.
But in her case, to the termination date.
And you terminated her on in December?
In November. So it will be prorated, right? No, like for the period. So she would get the 5. No, I'm saying she would get the 5% up to that time.
Up to the time of her termination.
That's correct.
So the final salary was what?
Well, he says he's going to provide that number. He doesn't have that number, and he's going to provide it as soon as possible, the accurate number as to what her actual pay was at the time she was terminated, and was rate of pay, and was used to calculate her settlement.
Chairman,
yes, Member Guy.
Would it be improper in terms of calculation? And I'm sure Mr. Watson has a battery of officers who deal with finance over there. That 12.99 and adding 14% to that figure would take you to about $14.8 million at least.
Well,
so we will get the figure from Mr. Watson.
We will see what the final figure is, and we'd like to have that this week if possible.
Yes.
I don't think it should be beyond even Petrojam to provide an accurate number by the end of the week.
And if you look at the sheet, Chairman, I think the payout sheet that was used for the calculation. Did they have this? Sorry, just let me check. Right, so if you look at the sheet that you would have, it was in the package you got yesterday.
Yeah.
It would show 8 months salary at 1.131378.02 at 8 months. So that would give you, if you multiply by 12, that should give you an idea what the salary would have been at the time, and then you'd add the traveling.
13.576 million would have been the basic salary, plus all the other benefits.
Right. That's correct.
13.576 plus benefits at that time. So we would, what I'd like to know is
I would like to see every crime finish in Jamaica. And the children them, oh boy, it would be a happy world for them. Jamaica is very beautiful and nice, you know. There is nowhere like home. This place is paradise, you know. It's just the crime that really...
The two salaries. So it showed the salaries for the first letter, and it showed the salary change for this letter. So they tabled the first letter that member guy spoke about, but they also tabled two payroll change form. One showed the first letter, and the second one showed this letter that was tabled yesterday. But I'm not sure why they didn't have the second letter.
Yes, Mr. Johnson.
I have a difficulty, Chairman. And I think the question you're asking, Mr. Watson, there are two letters. One submitted to the PAAC after January last year, middle of last year.
About June, July.
About June, July, when
Right.
the PAAC meeting were meeting. On that day, at that meeting, the letter with the same date of January 30th, 2017, show a salary that was significantly less than the one that appeared in the ministry paper yesterday.
Yes.
So the point I'm making, when they came to the PAC, this letter is supposed to have been there, so the payslip issue doesn't arise. The documented...
You mean the second letter?
The second letter would have been there.
Should have been there, yes.
So the only conclusion one could reasonably come to is, as was mentioned, is that the letter submitted yesterday represent a doctoring of the first letter to reflect the higher numbers which she was being paid up at.
No.
Both letters have the same date.
There were two letters, as I understand it. There were
Here
two
they are.
letters, Chairman, there were two letters. That was the letter member guy spoke about, is the first letter. And then there was a subsequent change, even if the dates were the same. It was done after, but the dates, and that subsequent letter now reflects the one you saw. Is that there were actually two letters. I don't know, because yesterday when I was preparing the documents, I assisted with that. I was asked, do you want both letters? It's by my HR, and I said no, because the first letter doesn't matter, the letter that member guy talking about.
But
So
Mr. Watson, when you say it doesn't matter,
no,
it is
because,
what was
because
presented to the PAAC
I didn't know that. I didn't know
halfway through
about that.
2018.
No, I didn't know about
and it's taken 6 months or more for the actual correct letter to be presented to Parliament.
But
Why was the wrong letter tendered to the PAAC with a lower figure, and why did it take Petrojam 6 months to correct that matter? And why was that not brought to Parliament or to the PAAC's chairman's attention to correct the false document, the incorrect document that was tendered as a legitimate active document, when in fact it had been superseded and replaced by a subsequent letter bearing the same date? Why was that?
I couldn't answer that, Chairman.
Perhaps someone else from Petrojam. I'm being invited to ask, and I think it's a good question. Yeah. Why was it not corrected? Why was the wrong letter tendered to the PAAC? And why was it not subsequently corrected? Not until the ministry paper tabled in the House yesterday. Yes, sir.
Yes. So, Chairman, as the acting...
Just identify yourself, sir.
Telroy Morgan, I'm the acting manager for refinery optimization and business support. As the acting general manager at the time, the original letter was what was presented to me, along with two payroll change forms. One speaking to the original letter, and a second change form notice speaking to an increased figure on the basic amount, so Mrs. Ramarak. So that's the information that I had at the time, and that's the information that was submitted. Well, it would have been several officers at the time. I can't remember exactly who. I would have gotten it from the HR department, But that's the information which I received.
The HR department headed by the officer whose termination we're now discussing.
Well, the information was requested from the HR department.
So it was under her watch that the wrong letter was tabled to the PAAC. A letter that was misleading the committee as to the terms of her own employment.
Received the information last year, I think around early July it was.
Mr. Chairman,
Member Wilmington.
The then acting general manager said that he got a copy of the payroll stuff for the original figure, and then he got one for the change figure. And the letter that the first one he saw, the first pay stub was based on the letter that he saw, the original letter that came here. The time that he saw those based on what he said, when did that come to PAC? In July?
June, July,
around about the same time. What I want to know then, if he saw a separate letter with a higher salary, or a separate pay sheet then with a higher salary, did he ask any question? What question did you ask when you saw a difference on the pay stub? You must have looked at it as a discrepancy or something. Did you ask a question as to why there was a difference in those two pay stubs? And having asked that question, did you ask to be shown the new agreement that you let employing her? Did you ask to see that?
So, Chairman, in answering that, the process with any changes at the refinery speaks to the same payroll change form. That is what is utilized. I wasn't privy at any time for any new letter. I didn't know there was a new letter that was generated. I'm only hearing about this new letter for the first time today. I didn't even hear that last night.
Thank you. Mr. Watson.
Let me go back on it again. Let me go back on it again. I'm not satisfied.
Go ahead.
There was a change in salary and the pay stub. There must be some document somewhere to show that there was a change and authorizing that. And if you're acting as general manager, I would say you're derelict in your duty. If you saw something like that and didn't ask, now you're saying you got document from several persons. There's no way it could be run a corporation, whether acting or permanent. And I have a contract in front of me that states a figure, and the pay stub is correspond with that figure. And then there's another pay stub that speaks to an increase. I would have to ask, how do we arrive at that? And where is the document to support it? Because there must be documents somewhere to support that if and when you are called upon to answer a question as you've been asked now. And you're telling me that it's the first time you are seeing that letter, yet at the time when this letter came to the PAC, it was around the same time when you saw those two pay stubs.
Yeah. So,
please,
respond to Member Wilmington again.
Chairman, may I clarify? And to be absolutely clear. So there was an original letter that spoke to the 10-point-something million, right? There is a change form, there is a notice of pay that goes with that. Okay, fine, that clear. What was also presented to PAAC was actually a payroll change form which spoke to the new salary, right?
What's the date of that?
The date on this one speaks to, interestingly, it had the same date as February the 9th, but interestingly, the signatures on it, one was approved, the first one was approved on the 17th of February 2017, and the second one was approved and signaled retroactive payment on the 24th of March 2017. So, for clarity, as the acting general manager, I saw the change notice. Clear. What I didn't see was a new agreement. And let me just say categorically, for any changes in the organization regarding pay, this is the vehicle, this is the document that is utilized for any changes in the department. In other words, for me, when my salary goes up, I don't get a new letter. What I have on my file is a change a payroll change form. So that is what governs the change.
Mr. Watson, when in your view, or when did you become aware of the second letter dated January the 30th? Mr. Watson, I'm asking, when did you become aware of this second letter's existence, the one that was tabled yesterday in the House with the $12.97 million salary?
I wouldn't have really gone and looked at the letter, but I knew that. So I would have seen the letter yesterday when I was asked to present it. I haven't gone to look, but I've seen the document when we were putting together information. But it's not something that I would have picked up.
Mr. Chairman.
Like that.
So you're not sure when you first saw the second letter?
No, but yesterday in putting together the package, I went and
you saw it then?
That's
so
correct.
You don't know when it came into existence, that letter?
No.
That's what I wanted to ask the Acting General when he was acting. Is it the practice to write a new letter? Where did he go? Sorry. Good morning. Is it the practice to write a new letter on the same date?
Not, I can't respond. If you're asking me?
No.
Oh.
He said that for him to change the salary, what he goes off of is that change form.
Correct.
So when that change form is brought to him, he acts on that change form. So he would not have known, I'm assuming, that how it was approved, etc. He just gets a form, he signs off on it, the pay is increased, correct?
So well, Winsor.
But remember, he didn't sign the payroll change form as acting general manager. That was signed by the previous general manager.
No, I get that, but he acts upon the form. Go ahead.
Well,
let me hear what you're saying.
Remember, he was presenting documents to the PAC a year plus after all this took place. So he was collating documents and he's explaining why the document that was presented to the PAC was essentially a false document. It was not the document that was in effect at the time.
No, but what I'm trying to get, Mr. Chairman.
Superseded, we're told by a letter dated the same date, the origin and timing of which we do not know.
No, Mr. Chairman, I get all of that. What I'm asking him, what happens in a corporation, because I've also seen the Prime Minister's ministry paper about non-disclosure agreements and Cabinet taking a decision about how we now deal with information. But if you have a situation where you have a job letter or a job offer letter with the same date with two different salaries, I'm trying to understand, one, who prepared the job letter after that to reflect it? Was that job letter prepared before? Was it prepared after? And why would somebody be so negligent, and that's as high as I'd put it, or incompetent to prepare a letter with the same date, January 30th, 2017, with two different salaries? And nobody picks it up in the organization.
Well, obviously the dating of it was deliberate. It was deliberately dated, backdated to that date. Clearly. As to when that second letter came into existence, we do not know. Remind me of your name, sir?
Morgan.
Mr. Morgan says that a year plus after the lady started to work, what was presented to him and that he presented to the PAAC was the original letter. That letter, it appears based on the ministry paper tabled yesterday, was not in effect. That letter had been superseded, we're told, by the letter with the higher salary. However, nobody can tell us when that second letter came into existence. Mr. Watson says he became aware of it yesterday when he was collating the papers for the ministry paper.
Well, Mr. Chairman, one of the questions we had asked Mr. Watson last week is, where's Mr. Grinley? And nobody can seem to find Mr. Grinley.
Yeah. Member Monty.
Yeah. Mr. Chairman, the ministry paper and the documents attached yesterday were helpful, and they proved that we were misled last week by the officials having to do with the actual settlement amount, which was approximately 13 million rather than the 9 million that we were told. And I think, unfortunately, while this package gives us more information, it is still deficient in terms of giving us all the information. And I would like to draw the committee's attention to the fact that all of yesterday, in many news media houses and their talk shows, they were referring to a letter dated August 24th, 2018, addressed to Mrs. Ramharak. And, well, it was addressed to Mrs. I'm looking at what is purported to be a copy of the letter. And the subject was invitation to a disciplinary hearing. And it lists 19 charges, many to do with facilitating improper use of company funds, a number of them to do with dishonesty, a number to do with gross negligence. First of all, can you provide us officially a copy of this letter? I'm assuming it's a genuine letter that is circulating in the media. And I think for the record, the committee needs to have this letter.
What's the date of that letter?
August 24th, 2018.
And it's on Petrojam's letterhead?
On Petrojam's letterhead. It's signed by Tamara Robinson, legal officer.
Is Ms. Robinson here?
Yes. She's here.
And it's titled Invitation to a Disciplinary Hearing. So you can confirm this is a bona fide letter.
Could Ms. Robinson confirm on the record?
Yeah. Ms. Robinson, are you here?
Good morning, everyone. Yes, I can confirm that a letter dated August 24, 2018 was issued to Mrs. Ramarak, inviting her to a disciplinary hearing. I'm not sure if the letter that is in the member's hand is that letter, but there was a letter.
Did it have 19 allegations of misconduct?
It had 19 allegations of misconduct.
All right. Rather than us trying to verify the document that is circulating in the media, I would like to ask that this document be officially provided to the committee, Mr. Chairman, by Petrojam. And in addition to this letter, the subject of which was invitation to a disciplinary hearing, could we also receive the minutes of this disciplinary hearing? I believe 2 days or whatever number of days of hearings were held. Could we have the notes or the minutes of this? I assume it was documented at the millions that it was costing Petrojam. I assume it was documented. And also, could we have a copy of all the related legal advice that Petrojam received around this matter of the disciplinary hearing and the settlement for Mrs. Ramharak? It is she's sometimes referred to as Ms. and sometimes Mrs. So let's, what?
Yeah. So the request is for that letter of that date to be given to us, the notes or minutes of the hearings that took place, and copies of any legal advice that Petrojam received around this termination issue with the former HR manager. Mrs. Dalrymple Philibert.
Thank you very much, Chairman. I have listened to the discussion.
No, Mr. Chairman, I wasn't finished.
Yeah.
I beg your pardon?
No, I hadn't finished my.
Oh, he's not finished. Let him finish, and then we'll get to you.
Just finish. So that's just in terms of asking for the complete package of documentation. But as it regards the disciplinary committee, could I ask if the the members were those that were mentioned in the media, and in particular, if the Gareth Forbes is the same person who was murdered in January of this year at his home in Stony Hill.
That's correct.
So he was a member of the disciplinary committee that sat in October, I believe it was last year.
Right, the disciplinary committee comprised 3 persons, Patrick Foster QC, Gareth Gawain Forbes, and Christopher Bond. Bond.
But their work was aborted because of the determination was made that it was on a cost-benefit analysis. It made sense to terminate. I'd just like to go ask about the cost-benefit analysis, Mr. Chairman. And this was, we had attached to Ministry Paper 10 yesterday, a 1 sheet, which I don't know if you're familiar. I imagine as a legal officer you would be familiar with. It was titled Cost-Benefit Analysis.
This is it.
HR Settlement. You're familiar with that document which was provided to Parliament yesterday evening?
Yes, I
am. Could you say who did this cost-benefit analysis? Who is the source of this cost-benefit analysis? Who is the technical person that did this?
The cost-benefit analysis was prepared internally by myself and Mr. Watson in consultation with external counsel. So the figures represented in respect of the continuation of the hearing, legal fees, and all details were provided in consultation with external counsel.
All right. So you are one of the authors of this. So my question can properly be directed to you then. There are 2 columns in this cost-benefit analysis. The left column says settlement amount, 8 months gross salary, and then 10.079 million, or 8 months gross salary at 1.259 million per month, which is a figure that is a brand new figure because it doesn't accord with any of the others that we have seen. In fact, the payout statement has 1.131. This has 1,259,951 as the per month salary. But that totals 10.079 million. And then the second line in the left, second and final line in the settlement column says settlement total 10.079 million. And then it has a note below that says reputational costs of perception of settlement where breaches identified by Integrity Commission and Auditor General have not been included. So we start off, first of all, by understating just the HR settlement amount, which the payout states as 13.374, but in your cost-benefit determination, you use 10, and then you explicitly ignore reputational costs of perception of settlement, where breaches, etc., which is essentially speaking to the moral hazard argument as what signal are you sending to all public servants who might be facing 19 disciplinary charges. But let me move over to the right column now. Estimated costs for the remainder of the hearing. You have legal fees, 1.5 million. Panel fees for 40 hours at 100,000 per hour, $4 million. Venue costs for 5 days, $80,000. Salary for duration of hearing, and I assume this is salary for Ms. Ramharak because it uses the same 1,259,951, estimated time 3 months, 3.8 million hearing costs total 9.3 million. At this point, it's still less than the settlement total. You then go on and say settlement versus hearing completion minus 719,000. So at this point, you even by your figures, you're saying the company is ahead. But then you add something called IDT process. And you say potential legal fees, $3 million, potential IDT award, and you have an asterisk, $23.148 million. And down at the bottom you say IDT cost total $26,148,000. Now your asterisks, I'm assuming the asterisk attempts to explain how you came up with that figure of 23.1 million. And it says our attorneys advise that there is a 60 to 40 chance that the IDT will rule in favor of the employee. That's a 60% chance that the employee would win. And then you say the IDT usually awards compensation at the basic salary for the period between termination and the date of the award, and this period is usually 1.5 to 2 years. 2 years was used. Basic salary is $964,000 per month, and that's how you come up with the IDT cost total of 26.1 million. You then combine both the disciplinary hearing costs and the IDT costs, and it totals 35.5 million, from which you subtract the 10 million to get that you are better off. The company is saving 25.48 million on the basis of this cost-benefit analysis. And have I fairly represented the one page that was given to us in Parliament?
Member, you have discussed some of the contents of the... My name is Tamara Robinson. You have indicated, I'm the legal officer and corporate secretary for Petrojam. You have indicated some of the figures and information in the cost-benefit analysis. However, I'd like to add information that would assist your understanding of the document. Firstly, we were asked to prepare a comparison between the known settlement amount and the legal cost to take the matter all the way to the IDT, right? So initially you mentioned that the figure of 1.259 is a new figure. That figure actually represents the combination of the base salary and traveling per month, right? So if you look at the sheet that had been circulated, you will note that the total compensation, the 8 months, is there's a 10.1, I'm not entirely, let me know.
10.162,
right,
which includes 1.11 million
right
of traveling.
So this is the combination of, at the time, based on the figures that I would have had, the combination of the base salary and traveling, right? And the known settlement figure was this 10.07, right? The exercise was to compare the settlement amount with the total cost, total estimated cost to take the matter all the way to the IDT, right? You had also mentioned that
who asked you to prepare it on that basis?
The instructions came from Mr. Watson to prepare the document, right? And it was prepared with a view to assist in the final decision making in respect of the settlement, right? Secondly, the member indicated that we deliberately, or there's a deliberate attempt to ignore the reputational costs. As you would appreciate, I certainly would not have had the competence to assess the reputational costs. And that was not the exercise that was put.
To many people, their reputation is priceless.
Right. What this was
So because you couldn't assess it, you put it as 0 in your calculation?
No. It's meant to indicate that this assessment is limited to the actual costs, right? It's meant to indicate that these are costs to be considered, but it would have been outside of my ability or even my call to determine whether or not a decision should be made exclusively on the basis of legal figures presented. That is a decision that ordinarily does not fall to the lawyer or any lawyer generally.
What you're saying is you were highlighting that this is a factor that in your view was relevant, but you weren't attempting to put any number to it because you didn't consider yourself competent to do so, but you thought it was relevant and should be taken into account as part of the overall calculus as to whether or not to proceed down that particular path?
That's correct.
So what I want to ask, on the right-hand side.
I'm pursuing this line of questioning till it's finished. I think it's very relevant, and then we'll get to you. You'll get your chance.
This morning, Dr. Trevor Monroe, who was a practitioner, industrial relations practitioner for 25 years as president of UAWU, said that he had looked on the documents, and in his view, and I must say that I share that view looking at the documents, that given the clause in the letter, in the employment letter outlining the terms and conditions, the section is titled Termination Without Notice. And that section says we may also terminate your contract of employment with immediate effect, without notice, and with no liability to make any further payment to you, if you are A, guilty of any gross misconduct affecting the business of the company, B, commit any serious or repeated breach or non-observance of any of the provisions of this agreement, or refuse or neglect to comply with any reasonable and lawful directions. C, are in the reasonable opinion of the management negligent and or incompetent in the performance of your duties. And I don't need to go on to the other ones. Well, G says are guilty of any fraud or dishonesty. Now, all of these are subject multiple times to the charges in the letter, the 19 charges. So he said, in light of the fact that procedurally Petrojam was impeccable in following the procedures of the Labor Relations Code, in assuming that these 19 charges were not laid without evidence, since you had taken legal advice, in his opinion, he said there was 0 chance of Mrs. Ramharak being successful at the IDT. How do you explain this 60% chance of her being successful, which you have used in the calculation, even though procedurally Petrojam was impeccable, and in terms of the 19 charges, on multiple of those 19, almost all 19, were the basis for dismissal for cause and without any further payment and without notice in this letter, even the amended letter which you have presented, which is a letter much more favorable to the employee.
Ms. Robinson.
We sought and obtained legal advice in respect of our chances before the IDT. And the legal advice was that the IDT is very employee-centric. There is almost a bias towards the employee, and even the slightest procedural breach can tip the scales in favor of the employee. This is legal advice that we obtained from a reputable and established counsel.
And you're going to provide that legal advice to us in writing?
You have requested it, and so we can provide it.
So the effect of it would seem to be, PS and Mr. Watson, either of you, the effect of that would be, no matter how egregious the conduct of a public official employed to a public body, if they make a fuss about being terminated and get a lawyer on board to drag out the proceedings by not being available for the scheduled dates and so on, a cost-benefit analysis would warrant them being paid a multi-million-dollar settlement for termination. That is the precedent that is being set in this case by the decision that was taken to settle with this lady on these terms.
I think I'd like to take that. I don't think, Mr. Chairman, I can speak for all public bodies, but I think we have to look at other factors. So when I inquire, can we use even the point that was raised by Member Bunting as a basis for termination? I was advised that according to Labor Code 22 or one of them, even though you have that in your letter of employment, you cannot summarily dismiss. You have to still go through a process. So that's one. So I inquired about all of those things. Can I use these clauses? No. Can I do this? No. So at all points, the lawyers were saying, look, if you breach any step of the process, you are going to lose. So that's one.
So had Petrojam breached a procedural?
No. But you still would have had to continue through the process. So what I'm saying is, so when I went back, pardon?
Wait, Member Daly, can we just?
No. So the other point is that, so when I went back to Petrojam, we had several HR issues. We had staff members who had been demoted. We had people who were shifted into different positions. We had people who were terminated. We were in the middle of union negotiation. We had job evaluation to do. We had reorganizing to do. The staff morale was very much down. This lady was coming to work every single day, basically filling up a slot and preventing us from moving on with the business. And that is the basis of looking at it. But we did discuss it with the lawyers. We looked at options. We couldn't premeditate the intention, but we did look at all the options. But when you look at what the staff was going through, and the fact that...
So could I ask you though, so what, this note on this sheet, reputational costs on one side of the ledger, reputational costs of perception of this settlement, where breaches identified by the Integrity Commission and Auditor General have not been included. So you see that there is 19 allegations, quite serious allegations of various breaches of our contract of employment. The reputational cost of the company settling and paying her a multi-million-dollar settlement to leave the company with all of this hanging over her. What figure did you attach to those reputational costs, Mr. Watson?
We didn't put a figure to it. It was
I see.
But Mr. Chairman, it was a matter that we put that to identify. Remember, we have a procedure that we follow. So having gone through this step, then I would have gone to the board, we would have discussed it with the board, including the effect on the company, including the reputational argument, and we looked at it holistically and said, look, we cannot run the business like this. We cannot run an organization. We can't fill the vacancy. And we had a lot of things we were trying to do to bring back the staff morale. And that was part of the basis of the decision.
Well, that approach is a recipe for impunity. That approach is a recipe for no accountability. And that approach is for a recipe for rewarding corruption, in my opinion. Mr. Bunting, I'll give one final question on this line of questioning.
Yes, just to complete on this same issue. Attached to the ministry paper number 10 that we received yesterday is a sheet entitled Chronology of Separation of HRDA Manager. Probably Ms. Robinson, I should direct this to you as the legal officer. Do you have this document? Okay, it starts off, well, the bullet point 1 goes to significant lengths to school us on the legal advice that an employer must comply with the requirements of Section 22 of the Labor Code prior to terminating the employment of any employee. The section is applicable irrespective of whether a policy or the employment contract provides for summary dismissal or whether there has been gross misconduct on the part of the employee. And it goes on for a number of, for 2 paragraphs, really emphasizing the importance of complying with this process. Have you been at how long have you been at Petrojam, Mr. Ramos?
I've been at Petrojam for 5 years.
Okay, so could you tell me, when the previous HR manager was dismissed, I believe her name was Rosie Scott Heron, did the company comply with the requirements of Section 22 of the Labor Code as has been so scrupulously laid out in this case? First of all, did the company comply?
No, the company did not.
The company did not comply. And could you explain why in the immediate previous case the company did not feel burdened? You are the legal officer. You must have been providing advice to the general manager.
Chairman, may I seek your guidance in this particular matter? Is this particular matter still sitting with the IDT?
I don't know the answer to that.
So in those circumstances, if the matter is still sitting and not determined by the IDT, perhaps my friend may
Are you asking a question or you're informing us?
I don't think it prejudices anything before the IDT. Please continue, Member Bond.
Yes, I was asking...
Chairman, what I heard just now was an admission that there is a breach of the code.
My understanding on that particular matter is that it has reached a particular point in terms of where it's at, where this would not be relevant to the outcome. Anyway, the question is, you've answered, you said that the code was not complied with in that case.
Right, and I was seeking from the legal officer of Petrojam an understanding of why she would have been so careful in elaborating the importance of compliance with the process in the case of Mrs. Ramarak or Ms. Ramarak, but not in the case of her immediate predecessor, Ms. Scott Heron.
The former general manager took that decision and no consultation was made with me as the legal officer in respect of that decision.
So you didn't learn of that termination, and notwithstanding that he didn't consult you, you didn't offer him this advice?
So I learned of Mrs. Scott Heron's termination while I was on vacation. When I returned to work in January, I indicated to the former general manager that the law does not permit summary dismissal in the manner that he had done it. He was not receptive to the advice. I indicated to him further that I could get external counsel to assist him in familiarization with the local labor landscape so that he could be guided going forward. That did not happen.
Yeah.
So you understand that the public, and certainly myself as a member of this committee, I am perplexed at the inconsistency in
Chairman.
the application of
Mr. Chairman, sir.
labor code
1 second.
by Petrojam,
Mr. Chairman,
as
sir.
it varies from one officer
On
to
a
the
point
other,
of order, Mr.
in the
Chairman.
exact same
Mr.
position
Chairman, on a point
in the
of order, sir.
company,
Mr.
based on one being
Mr. Chairman, on a point of
removed
order, sir.
summarily, inconsistent with the
Mr.
law.
Chairman, on a point of order, sir.
Yeah.
What is the point of order?
Mr. Chairman, we realize that the committee meeting is taken over by one speaker, and we realize that the questions are flowing one into the other, and nobody else is getting a chance to partake of the meeting, Mr. Chairman. Can you rule that our member give other members some level to ask questions and to share their concern, just the same, Mr. Chairman, please?
I told you before, I indicated before, that this particular line of questioning was relevant, and I was going to allow...
I am not worried about the line of question being relevant, so what I'm worried about is that it goes from one question to the next, and it is flowing as if he's the only one here. Mr. Chairman, if you don't want our presence here, you can make it known, and then you and the member can stay here all by yourself.
Yeah, thank you,
Mr. Chairman, sir.
Thank you, Mr. Date.
Mrs. Dalrymple, I've been trying to
yes, and she's next on the floor.
Say something.
She's next
so
on the floor.
So what is saying?
I'm next
you
on the
share
floor
the
when
floor.
I indicated you.
Saying you share
15 minutes ago, Mr. Chairman.
Mrs. Dalrymple.
15 minutes ago, Mr. Chairman.
Well, she's 20 minutes ago. She's 20 minutes ago, sir. So she's before you.
Exactly so, Mr. Chairman. And you have one member speaking 15 minutes. 20 minutes?
Yes, because he was pursuing a line of questioning which was relevant, and I wanted to allow him to finish.
No, Mr. Chairman.
It is fair, and it has been done. We're moving on. Just one question I have. This document, Miss Robinson, Miss Robinson, who prepared this document?
I prepared that document, sir.
You prepared this document. Thank you. Mrs. Dalrymple Philibert.
Thank you very much, Chairman. I just want to preface my remarks by saying that I have absolute respect for the chair, and I want to say that on this side of the fence, as with everybody in this PAAC, and I think Jamaica at large, we are concerned about the situation at Petrojam, and we all want to see the matter aired and aired properly so that the whole issue of governance is dealt with properly. But I want to just make 3 points that are very important.
Yes, ma'am.
The first one that I want to make is as it relates to the discussion with the letters that were both dated on the same date, sometime in January, which is very concerning. And so, but I want to make reference to the fact that that was in 2017. And at that time, the Prime Minister did not have responsibility for the ministry at that point. I want to go on to say, and I'm very happy about it, and I think all of Jamaica should be happy, that as Prime Minister, he tabled yesterday the full and correct document, which is why, as a country, we can now examine it, pull it apart, and find out what went wrong with it. All that was tabled yesterday is full disclosure and correct disclosure under his hand as the minister handling this whole thing. And as an attorney, and Chairman, you are too, you know that in any matter that you have before the court, you say to clients all the while, they say, what are your chances of success? And it really depends a lot on precedent, and it depends on who is doing. And we
I'm going to ask a question to anybody here, or are you just making
No,
a
I want to make an important comment as it relates to the discussion, because I think that the country is anxious to see where we went wrong with governance at Petrojam, and it is obvious a lot of things went wrong, and we have to clear it up. But I also think it is important, while we do that, to indicate that what came forward happened under the previous minister, and that what has been tabled yesterday, which is giving us the opportunity to investigate anything, was tabled under the hand of the Prime Minister now handling the matter. So that what I'm saying is that we do have here full and correct disclosure, which is allowing us to unearth all that is wrong and for the matter to be corrected. And I just want to say on the matter of success and what is based on precedent. I don't know if you recall the settlement that Jennifer Edwards got, that was 17 million. And don't forget that Sharon Crooks and Factories Corporation, where there were a lot of breaches, that she got something like 32 to 33 months' salary. So let us not, there are issues that must be aired in this country, and we have to correct it. And I think that is what it is that this government wants to do, which is why the Prime Minister has tabled everything that is there yesterday. So let us not discount the fact either that there is precedence, and we have to be careful. You can't just disregard and say because she had disciplinary matters, therefore her chances of success. Sharon Crooks had disciplinary matters before.
We don't have any information about Sharon Crooks before us. And on the first point, Ms. Damron, I'm going to ask you one question. One question arising from what you said about disclosure. You said the two letters date from 2017 when the Prime Minister wasn't the minister. What is peculiar, and which has not been answered, is how it is that in 2018, halfway through it, Petrojam tabled to the PAAC one of those letters, the first of them, with the acting general manager not being aware that there was another letter. And the current general manager saying to us that he saw this letter yesterday when he was compiling the documents for the ministry paper. That second letter, we do not know when that second letter came into existence.
And Mr. Chairman, I agree with you. And this is why I'm saying what has been tabled by the Prime Minister is allowing us to investigate and follow all the leads to where it is and bring some sort of settlement and decision to all that has taken place with the governance issue. That's all that I'm saying. There are questions to be answered, but let us understand exactly what it is. And you know, as members of this committee and other committees on which I sit, on both sides of the fence, there is anxiety and there is a need. We must address the issues and we must unearth them, but we must at least level the playing field so that everybody in the country understands that it is the intention of all of us, government and opposition members, to deal with the whole question of governance and deal with it satisfactorily, and that's why the documents have been laid.
Thank you for your patience, ma'am, and for your contribution. Mr. Clark, you had a burning question?
Thank you very much, Mr. Chairman. I too share great amount of respect for the chair. But Mr. Chairman, sometimes you cause us to get all riled up because of the way you chair your meeting. Notwithstanding, Mr. Chairman, I just want to add, and because of that I had to write down my thoughts, because I would have lost them in the time spent by...
I'm glad you could retain it for a few minutes.
Mr. Chairman, please, I want to be guided. Petrojam has been a troubled place for many years, Mr. Chairman. It spans over different administration. You know, this matter that is before us might be the straw that breaks the camel back. And it is for a good. It is for a good because what it does, Mr. Chairman, it is now giving us time to sit down and to delve in it and to make sure that what comes out of it, we get rid of all the bad and continue on a foot forward, Mr. Chairman. Mr. Chairman, the ministry paper that was placed before us is also a point at which we can start and make it better for the country that we seek to serve. It might not be that I have questions, Mr. Chairman, but I have concerns. Some of our members are here just to ask questions. Some are here to voice their concern. And this is my concern this morning, Mr. Chairman.
Thank you very much. I'm glad you had the opportunity to raise your concern. I'm sorry it took a few extra minutes. I'm glad you made your notes so you didn't forget what it was, and you've had a chance to say it. Mrs. Holness, you wanted to say something?
I know I stepped in a little late. I again go back to the concern as it relates to whether or not we reported when we made the report at the last PAC meeting, was a comment made in terms of this is the net settlement, or was a comment made in terms of this is the gross settlement, or was the comment that this is the settlement? So I can get to a better place in understanding whether or not the Prime Minister was misled in the information he was given to provide to the House.
Could I just, in terms of your question, Mr. Are you saying at the last PAAC meeting or the one last week?
Last PAC meeting.
PAC meeting. We were told that the gross settlement was 9.2 million. There was no hint of there, in fact, being a 13-point-something million figure from which deductions were made on account of tax and so on.
No.
Can I respond to that, Chairman? Because I am the person who had made a statement. And I believe that the statement that I made, and we made it in camera at the time, is that the matter was not straightforward, that there were several payments which were coupled in the entire amount that was paid, that there were things such as vacation pay and so on that would have been included in the matter. I think, and I don't have the Hansard statement before me, that I would have indicated that the net amount paid after the statutory deductions was 9.2.
Oh, no, so there was
a starting, I would love to see the Hansard figure, statement to go back to that, Chairman. May I
Chairman.
Please? May I please?
One second. Members. Let the PS finish her response to the issue. She is entitled to do so.
May I please?
We can respond to it afterwards. PS.
May I please? There was the matter of a lump sum payment of 8 months. In addition to the lump sum payment of 8 months,
Chairman, just a minute.
There would have
Mr.
been
Chairman,
payments.
just allow me 1 minute. PS, allow me 1 minute. The question that was asked by the member, the gross and the net figure, you mentioned just now that the net was 9.2. You're incorrect. Last week it was 9.2 as the gross. The net was 5.2 or something. So all we need to know, yes, I said last week, when a question is posed to you, confine yourself strictly to the question and we'll be all right. The question was the net and the gross. All you need to do is just say the net or the gross. Don't give any more. If you give any more, you're going to lead yourself in deeper waters. More questions are going to be posed to you that were unnecessary. If she asks net and gross, don't give us what was given for lunch and what was given for you. We're not interested in that. The question is, you did it correctly last week. Just give us the net and the gross. That's what you asked.
Okay.
Don't go down the road.
All right.
Last week, member, I gave that answer in the closed meeting. You were not in the closed meeting when I gave that answer. Okay.
Mr. Chairman, again, she's going down some slippery slope. It's not necessary. The question that is asked here. The chairman came back here.
Member Warmington.
Give me a chance, Chairman.
No, I want you to give the PS a chance. Huh? I want you to give the PS a chance. You've advised her not to go down the road of an expansive answer. She's not obliged to follow your advice.
No, just
so let her please respond to the question.
It suits you when she expand and expand.
It doesn't suit me at all.
You get a chance to dig more into her
it doesn't suit me or otherwise.
Yes,
it is
when she expand and expand,
She's
and
a
instead of saying yes or no, you
ministry.
and your team get a chance to dig more deep into her and what you have to say. Allow her. Please.
And you don't want that to happen.
Let's just say yes or no. I don't get, but the issue, she's come with things that are necessary. PS, just say yes or no, please, and just give us the net and the gross. That's all you need to do. But please give us the trivial thing.
Please answer truthfully and as you see fit. You're telling her to answer yes or no. I'm saying please answer the question.
You said she answered truthfully.
1 minute.
You're telling.
PS.
No, I did not.
Hold on.
You're telling her how to answer the question.
Hold on. Member Warmington, hold on. PS.
Yes, because you're in the middle of it.
I've heard you starting to respond, and I know why I have the concern. For me as an ex-accountant and auditor, when someone is terminated or chooses to leave, there are some things that are their due. So things like vacation pay, and if they're not taken, they would have been paid anyways. If there's any amount that they've already earned, so they've worked half of the month or 3 weeks out of the month, I'm not expecting to hear that because it's a part of the salary, regular salary. What I'm interested in is what is the amount paid as a result of this settlement in respect of separation, and whether or not we were misled in the figure that was given. If we need to consult Hansard to say whether or not it was said the net figure is, and at the time it's net of deductions, please ask for consultation on same, or if the gross was said. And I understand what Member Warmington is saying. I know people can make errors. It would be good if you need that clarification or confirmation to consult Hansard.
I can seek such clarification. Thank you, Member Holness. The lump sum figure, as would have been shown in terms of a settlement figure, also in the ministry paper that would have been presented yesterday, is, as we have been discussing, 8 months' salary. The information that I have as per the payout statement, which I understand from Petrojam Limited, is the audited payout statement, is that 8 months' salary would have amounted to $9,051,024.13. The employee would, in addition to that, have received other emoluments that would have been due to her at the time of the separation. That would have included matters such as vacation leave and so on. And so the total gross figure, when the amounts that would have been paid to her would have been added to the 8-month lump sum payment, would have amounted to $13,374,499. May I finish, please, Chairman? And 11 cents. Statutory deductions amounted to $4,170,876.30. The payment net, meaning after statutory deductions, would have been $9,203,622.82. For completeness, Chairman, the officer also had outstanding loans and obligations to Petrojam Limited. After those outstanding payments were taken out, the final payout amount was $4,189,328.87. So I am sorry if there was a misunderstanding last week, but I will ask for the statements from Hansard.
I must just tell you, I was very present, and I don't know if anybody else felt differently. The 9.2 million was communicated to us as a gross figure, and we were given, and we were told there were deductions, and we were given a net figure. There was no inclination, and I'm not making any allegations about motive or anything, but it was definitely presented to us at the time that the 9.2 was the gross figure, and it, in fact, wasn't. The gross figure was 13.374 million.
Which was why I was interrupting the permanent secretary, and I'm going to ask that we get the Hansard record. We were told, Chairman, that was $9.2 million gross, and that with deduction of certain statutories, as was indicated, that it went to that particular figure, and motor vehicle loan that was, and finally it came to the figure of 4.2 or 3.9, whatever it was. We were told, Chairman, and you were hearing clearly that it was the gross of $9.2 million.
Chairman, this member was not a part of the closed session. However, I actually clearly understand the PSA's response. The presentation, even in the ministry paper, of a total calculation in one document makes it far more challenging for persons to reconcile what is the settlement arranged that with the attorneys as against her total payout. So the question has to be very clear. If we are seeking to determine what is the settlement or what did she end up going home with. And what I'm interested in finding out is I'm not interested in our loans and our vacation and all of that. What is the settlement arrived at? And you would have asked other questions in terms of the legal ramification of why you thought it necessary to pay that amount. But what we are interested in, well, for sure, this member is interested in, is what is the settlement as a result of having to terminate, come to some severance arrangement. What is that payment? And
that figure would be 8 months' salary, which, as per the statement I have received from Petrojam, is in this 9,051,000 and some additional amount.
And that is after 4.17 million of deductions. Yeah,
Chairman.
And that was what not clear at the time at all.
Chairman, Mr. Chairman.
Mr. Jackson.
Settlement has to be 30.
Mr. Chairman. Mr. Chairman. Mr. Chairman, a lot of numbers have been bounced around, which in my mind is only to confuse. I was in that closed meeting, and what was clear in my mind when the question was asked, what was the gross settlement? What was the gross settlement? How much did the company agree to pay at a gross settlement? And that was clearly, PSU said, $9.2 million. After the 9.2, then all the other deductions include what she owed the company, like the loans, etc., would have been deducted. But no, I'm not finished. But the net benefit to her, rather the gross benefit to her, as part of the settlement, was 9.2. What we are hearing out of the submission in the ministry paper yesterday is that the gross settlement, the amount for the gross settlement was not 9.2, but rather $13.3 million.
That is not correct.
That is the difference between the gross told to us last week and the gross.
That is
it
not
says here,
correct.
grand total payment due before taxes and deduction, $13.34 million.
Yes.
That is the gross amount that the company agreed to, and not 9.2
No, that is not true.
you indicated.
That is not true.
Secretary. So let us settle on
that is not true. That is not true.
Mr.
It is no.
Mr. Witter, hold on.
And it is simple.
Mr. Camp members, can we try and restore some order to the process? Mr. Witter is burning to make a point.
Yes.
And I would like to give him the opportunity
My
because
understanding,
he hasn't done so previously.
My understanding is that his settlement is $9.1 million. Approximately, I don't have the figure. 9.2. That's the settlement for the separation. Now, the company would have owed her $3.something million for service that she would have rendered. That's not a part of the settlement.
That figure.
That's not a part of the separation settlement.
That 3.2 million
that she would
that
have.
you say that we're being told she was owed includes performance incentive of $2.75 million for a lady who was under disciplinary proceedings for 19 substantive breaches, was being paid in performance incentive of $2.75 million, but separate from her $9.2 million gross settlement.
That's a part of her contract that she would have earned.
That she
whether or
earned.
not.
How are you going to deduct that?
That's a part of her contract. The settlement is 9.2.
And the traveling allowance was part of the negotiated settlement. So
$3 million.
The 9.2 was not the total settlement. The total settlement was not 9.2, because even if you discount or say set to one side this additional $3.2 million that we're being told was ignored because it was going to be paid to her anyway. There's a $1.11 million of traveling allowance, which was part of the negotiated settlement, taking it to $10.162 million, which was nearly $1 million more than the figure we were given.
Yeah, but I'm just saying that the separation package is not 13 point something million dollars. That's not the separation package.
Mr. Phillips.
I must be clear on that. Yes.
Chair, I just wanted to find out from looking at the documents that was tabled to us in Parliament yesterday on the performance review that was done on Ms. Ramarak by the now General Manager. If she was still employed, Ms. Ramarak that is, still employed to Petrojam, with a review like this, what would your recommendation be?
Two things, member. The first thing is that the performance appraisal that you're looking at, it actually runs from April to March. So even though I did the appraisal, it wasn't for the period when she would have been absolutely appraised, right? Because I would have been there in July, and the period would have run from April 2017 to March 2018. So that is what the appraisal is covering. The way it works is if you get two consecutive scores like that, so the first low score, like unsatisfactory, you call them into a hearing and you say to our meeting, and you say, look, I'm not satisfied with this, with that, with that. You need to improve here. And you develop a plan to see how the employee can lift their performance. If it continues the following year, then you can take other action based on that, whether you terminate or whatever.
Okay, and then...
But you would have had to give it at least 2 years.
At least 2 years.
Correct.
And then now, seeing the normal elements of termination, and the first line on it was performance incentive from 2017 to 2018 of $2.7 million. As an employer or as the boss of this entity, you feel justified after a performance report like this and seeing that Ms. Ramarak had 19 charges against her, the issue of the investigation from the Integrity Commission, satisfied that this $2.7 million is justified in paying her at this point in time?
Well, let me, perhaps if I can just delve a little bit into the performance incentive plan. So this plan was developed almost 20 years ago. It was done with PwC assistance and approved by the ministry and the board. At the time, just to give you some background, at the time it came about when there was a freeze on wages for public sector workers. All right. So having done that, the way it works is you have a list of competencies, you have a list of objectives, and you do the appraisal of the individual based on that. Once you are appraised of a score, you are paid a sum of money depending, as long as the company meets its profit target. So if the company doesn't meet its profit target, there is no payment. So once the company does, then all the employees would be entitled. The issue is how much you get is dependent now on your appraisal score.
Right.
So one could say, you have asked me how I feel. It's not a feeling. The policy says this is what you're entitled to if you get this score. Now, perhaps one could say, well, there's a flaw in the thing, you need to improve on it. The answer is something we're willing to look at, and in fact, we're doing a review. But for the moment, that is the policy. It was duly approved, and we applied it.
And I just want a clarification. You're saying for a calculated score of 47.5%. This is out of 100%, I'm assuming. 47.5%. You are warranted a 2.7 million performance incentive. So, I mean, if this person had got 95%, they would own Petrojam.
Well, as I said, it's linked to your salary and your score. And it's a mathematical formula, and that's what it comes out.
Score less than 50% and you still earn 2.7. What if she had scored 95 or 100%? What would it have been?
Wait.
Chairman, if I, just for clarification, I think Member Bolton is perhaps going down the wrong road, because what Mr. Watson is in fact saying is that the 2.7 accrued prior to this assessment being done and the score.
No, what Mr. Bunting is saying is that if the assessment of 47% translates to a payment in cash of 2.75 million.
But the 47 does not relate to the present period. It relates to a period.
Chairman, can I finish?
Which is before he did his evaluation.
Can I finish asking my question, please?
Can we clarify that? What the 47% that you were referring to is in what document? On what date?
Document called Performance Review Form, 1st of April 2017 to 31st March 2018. It was one of the attachments to Ministry Paper number 10.
Right.
And the incentive was for the 17-18
Same
year.
Period.
So it's the same period, Mr.
So
Campbell.
I did,
same period.
And that's what I'm explaining, that I did the appraisal, even though I was not there, with the support of the other staff members who were there. And in my opinion, it was an unsatisfactory performance at 2.3, I think. But based on the policy, that is how the formula worked out. And that is why I made the point that one can look at it in hindsight.
Member Phillips, I had acknowledged Dr. Guy, but is yours relating to the same issue? Or is it a different issue you want to go to?
I wasn't finished, but...
You're not finished? Go ahead, if you're not finished. I didn't realize you weren't finished. No, wait. Mr. Member Phillips is not finished. Let him finish.
I even lose my chain of that.
Go ahead, Dr. Guy.
Thank you, Chairman. Mr. Watson, yes, there are two questions I want to ask, but I'll ask Mr. Watson one first, Chairman. You indicated just a while ago that based on the fact that the former HR manager would have been working with the staff, that a decision was made to as it were, expedite her departure, my choice of words, by the settlement. The last time we met, I asked you about garden leave. And you indicated to me that that particular facility was not available to her because she was not a contract officer. And garden leave was only available for contract officers, such as the CFO.
No, I didn't say that. That garden leave is only applicable to contract workers?
Yes.
What was the reason that you indicated?
Fine. Why did we not send her on garden leave then while this was being done? So, and you answered, sir, you started by answering, and we can check Hunchard again. It is only available to contract officers.
That question was asked.
I remember the question being asked about sending the person on garden leave. And I said to you that one of the things you would end up doing, I'm trying to remember, is you'd still be paying the individual, but you can't fill the slot, so you end up going right back where we are now. So you have an individual, you're sending them home, you're paying them while you can't fill the HR position, and there are many HR things that we wanted to do that were outstanding, and we couldn't do it.
Yes, you did say those as well, but you did indicate as well that there was a difference in terms of what was available to you as it relates to permanent employees as opposed to contract officers. And we will get the answer.
But Mrs. Ramarak was not a contract officer.
No, we understand that.
Okay.
We understand that now.
So I think
And
the
mine was
impression was
asked in
given
relation to the CFO who is
that
on
the
guard
guard
leave.
leave facility, for want of a better word, that mechanism was not available in her case. That was the impression that was given. You're saying that that isn't your recollection of what you were saying. You were just saying that it wasn't the way you wanted to proceed because
It's just not the way I want to proceed. I mean, it's something that came up after as well, but no.
My question is now, Chairman.
Yes.
Ministry paper number 10. We see here, and Member Bunting started earlier on the chronology of separation of HRDA manager. And we are told that there was a disciplinary, a panel was convened for a hearing into the matter. But I've been scouring the documents, Chairman, and there has never been an indication in these documents that there ever was a disciplinary panel meeting. All we are being told, or we have been told in this document, is that they were postponed based on requests made by Mrs. Ramarak to indicate that her legal representative was not able to attend on those dates. They were rescheduled for a particular date. The scheduled date of November 1 was cancelled due to unavailability, etc., etc. Did the committee meet, and how many times did that committee meet? And could the committee be told, this committee be told that information?
It's not explicit, but it's inferred.
It's inferred, but
if
I
you
mean,
could clarify, it's inferred that they met on October the 26th and the 29th, but the scheduled meeting for November the 1st was cancelled because her attorney wasn't present. Can you confirm, is that the occasions on which it met, those two occasions?
Yes, the panel met, the proceedings went on October 26 and 29. The date of the first was postponed because her attorney was not available.
And
it met twice?
Yes, it met twice.
On those two occasions? All right, and Member Bunting had asked for the minutes of those meetings. All right, number 8. A settlement agreement was signed on Wednesday, November 14, and was approved on Thursday. By whom? I'm referring to the same document, Chairman. Chronology of separation. By whom?
Who approved the settlement on Thursday, November 15th, 2018?
So that would have been me.
So that the approval of the settlement didn't go to your board?
Yes.
When did they consider it?
It would have gone through on the 15th, right? On the 15th as well.
So it wasn't you, it was the board?
Well, there's a process. So we would have negotiated, we came up with a number, we went to the board, and we also went, as I informed, that Ministry of Finance was advised, we consulted with them. We got the board approval, and then we signed the go-ahead.
And
one second.
Okay.
It's Mrs. Holness after, yeah.
Yes. And Chairman, all right. The Ministry of Finance, we were told that this was approved by the Ministry of Finance at the last meeting, that this particular settlement was approved by the Ministry of Finance. Yes. But 12 said that the Ministry of Finance indicated that the settlement agreement was an internal matter which did not require its approval. Now, is that this particular statement an indication of the approval of the Ministry of Finance?
So I may have, if I can take that question, because I really should have clarified the point. So I spoke to the Ministry of Finance about the matter that we were going to settle, and they came back. I wrote to them actually to confirm, and they came back and said it's an internal matter. The board and management can make the decision.
They wrote to you to that effect?
No. I sent them an email confirming that discussion. And he replied, the deputy financial secretary replied to the effect that thank you for the update, and I can't remember.
So it's done by email?
So they were emailed.
It was by email. They told you it was an internal matter that didn't require their approval.
Right. So no, he told me, and then I wrote to confirm that conversation. But he replied to acknowledge what I sent to him.
So you had a discussion, oral discussion about it, and then you confirmed it in an email to him, and he responded to confirm the confirmation.
That's correct. He confirmed, yes.
Mrs. Holness.
Thanks, Mr. Chairman, through you. I actually am very interested in what has been the improvements and the changes since the old GM and HR manager left. With your new board in place and some amount of reorganization taking place back at Petrojam, could you give us some indication as to what the performance of the entity is like now? And as a follow-on from a question or a statement made by Mr. Bunting earlier, I would answer it this way. If it is that one believes you have erred in the past, as he asked what happened in December when the previous HR manager was dismissed without due process, I don't believe if we have erred in the past that we should continue. So HR manager, I would say it's the appropriate thing to do if it is that we follow due process, and all our members at other meetings are very interested in due process being followed. It is commendable that that was done in this case, and we should do so going forward. So I have...
Even if it involves paying multi-million-dollar settlements to persons who have the litany of
follow
allegations.
Due process is my statement. Chairman, follow due process. There are some things, Chairman, that as a government we need to fix at the level of government, instead of having procedures and policies in place that actually allow people to be paid large sums when they should not be paid. This is hardly the place for us to come and argue after the fact, because we have set up our government in such a way over many years where people are paid large sums on separation that shouldn't, and even where people don't have contracts at all. You have seen rulings where they get millions of dollars, far more than many of us earn as MP, as nurse, as doctor, as police, as soldier. So, Chairman, I'm not going back there, because the civil servants have to just follow what is in place, and we would not beat up on the HR manager if it is that she has said, look, I wasn't consulted, I wasn't involved, I am now the person presiding over this separation, legal officer, and I'm now presiding over this separation, and I'm going to give the proper advice. So I am beyond that point, more than to say to Mr. Bunting that we can't continue to do the wrong thing still. So GM to you, GM, I would like to understand with the HR manager gone, with the new GM, what's the improvement?
Sorry, this is a public service announcement. Sorry, I've been asked. Toyota 1632JD is blocking someone. If you could please move your vehicle. Toyota 1632JD. They're blocking someone who wants to leave. Please, just remove your vehicle so the person can leave. Mrs. Holness, sorry, ask your question.
So Jim, over to you. I'm very interested as to whether or not we have seen any significant improvement in the organization as a result of the changes made.
So it's a good point, and you referred back to what?
Under his watch, you mean? Under his watch?
What?
Under the GM's watch and the change in the board of directors, there are several changes, because you have a new board in place, a new general manager, you would have had several meetings, discussions, you would have had the benefit of the audit, and I would hope that the audit is what we have taken on board in improving some of the governance issues and internal control issues that were in the organization for some time. So having had the time back and being back in the seat, I would like to know and the rest of the country, I'm sure, where we are now.
I was saying, Member Bunting talk about why we couldn't, based on the letter, just summarily terminate, and I'm glad you raised the point. What would have happened is you're perpetuating the same thing that everybody is talking about. You just terminate without cause, then we end up going to court, and that is exactly what happened.
Without cause?
No, that is exactly, without following the process, my bad, following the process, and that is exactly what happened with Rosalie's case. So we terminated her, didn't follow any process, we're back at the IDT, and as you said, Chairman, you know the results, and it's going, I haven't heard the results yet, but I know it's not going to be a small figure. On another matter, with regards to the governance, with the new board, we have subsequently had several board meetings, several committee meetings, both ourselves, the local directors, and the PDVSA directors. So we've had committee meetings, we've had 2 board meetings, and we didn't have any for the entire year, 2 years or so. In terms of getting our information out there, we're working with PCJ. We have members of PCJ sitting on some of our committees. Within the organization, we got audit done by the Ministry of Finance to look at the org structure. So we're now working with the acting HR manager to start putting that together along with the HR committee of the board. We got approval from Ministry of Finance to write some of the org changes that were made inconsistently. So we had people that were demoted that should not have been, or shifted to other positions. We had to get the approval of the Ministry of Finance to do that. So once we get the sign off on the new structure of the board, we can then move to implement the org structure. Now, we got approval from Ministry of Finance to employ a new HR manager. So the ad was out in the paper over the weekend, so we're going through that process right now. In terms of operationally, we have instituted some changes, such as expanding our security operations, looking at diving, which we have been doing for the last several years. We now dive the pipeline, we dive the docks, just to ensure that there are no security issues. It's an ongoing matter. As a matter of fact, up to yesterday, we had JDF conducting dives as supplementing what we're doing, just to validate what we said we have been doing. Operationally, we have put in place a very strong oil loss program, and they have been doing daily oil loss balances, checking all our meter movements, oil movements, which has resulted in our oil loss coming down to about 0.2%, which is a very commendable number, and we continue to do that. The next step is to, I should mention, we've also had frequent meetings with the various departments. We're now going through our business plan to roll out to the rest of the department, the staff, in terms of what we plan to do for the coming year and what are the objectives and how we're going to set the different activities for the year. So have we turned the corner in terms of staff morale? I would say not yet, because even some of these matters still create issues. But I think we are seeing improvements. The communication, certainly between my office and the management and the staff, has improved. We have instituted the minutes that were complained about that were not being sent. We're doing that. The pricing committee, we have been meeting. We're going through and submitting the minutes to the various entities, the ministry. But we are also trying to expand that to possibly, depending on the board's position, whether we should bring in somebody from the Ministry of Finance. That was a recommendation of the Prime Minister as Minister of Energy. So we are now looking at all of those activities to improve our governance and transparency.
Thank you. Miss Flynn was next in line, but she's on the phone. I remember Don was after her, and then Mr. Jackson, and then Mr. Daly.
Thank you very much, Mr. Chairman. Mr. Watson, PS, do you think with all of that has transpired that this is the most appropriate time to look at revising the labor laws, seeing that in a number of cases the issues and the position that employees takes normally frustrates the process?
I can't respond to the...
Well, you're asking the General Manager of Petrojam for his view on the labor laws.
I can't respond to the revising of the labor laws, Chairman, but certainly one of the lessons learned out of this is that we internally have to look at our policies, procedures as it relates to HR and ensure that it is consistent with the current labor laws, because as you read in the letter, despite what is written in the employment letter, we actually can't take some of those actions anymore. So we have to revise that. We even have to revise our policies. But I don't know if the PS has an opinion on that.
All right. Member Jackson. Oh.
To also ask, what would be the potential implication of a new policy direction regarding the restriction that the PM has now put in place on non-disclosure agreements?
Well, you mean the cabinet? You mean the cabinet decision? Yeah, well, I mean, I guess that will guide them going forward. Mr. Jackson.
We'll comply. That's...
Well, Mr. Jackson.
Mr. Chairman, through you, sir. Mr. Watson.
Yes, sir.
I must tell you, I have great difficulty with, great difficulty with your option to go into this negotiated settlement in light of that list of serious 19 charges. I won't even go over the performance assessment that was discussed a moment ago. But you have an organization with an HR manager that you found was an impediment to the company going forward, as you outlined. And you have all of these serious charges. The argument that you choose to negotiate rather than fire her and let it take its course worries me. All employees of Petrojam, and you have been there before for how many years? 14 years.
13, 14, right.
Have you dismissed, during those 14 years at Petrojam, have you dismissed employees for cause before without going to the IDT?
We have gone through a process of dismissal, yes.
Successful dismissal?
Yes.
Without any financial...
Well, let me... I can't remember all, but let me give you
Generally.
for example. So we currently have the several dismissals that are in the courts, our IDT, our Ministry of Labor. We have the former general manager. We have the project director that was hired for the VDU project. So when the Prime Minister announced that the project is on hold pending the review committee headed by Mr. Zaka, we terminated those persons involved in the project. The ones that we could absorb into the company, we did. The project director we couldn't absorb, so we paid him out. But he's still suing the company on the basis of wrongful dismissal. Okay. Now, I'm just saying that there are different, so depending on the situation.
Yeah, no, because...
we have the matter that was mentioned with the former HR manager, Rosalie. Yes. So that's another matter that we have. We have one employee now that is suing the company for constructive dismissal, similar issues. So we do have a lot of issues like that coming from prior to. But the point is, what I didn't want to do, and certainly the advice in the discussions with our lawyers and even our internal counsel is, look, if we go down that route of just terminating, whether because you don't like the person or because the person was hired a certain way, you are going to end up in court and you probably will lose. And even when we had the 19 charges and we go to the lawyer and say, look, we have 19 charges, we have some comments from the Auditor General. What are the chances? We were still not getting, 80% absolutely sure you're going to win. The lawyer is cautious. We're getting a 50-50, maybe. That's one. The other thing is that even if you were to say, let's take the matter all the way through, between the delays, having the hearing, cannot fill the position, a lot of things can do. You could easily have ended up 6, 7, 8, I don't know what the number would be. It could be 6 months before, and you'd have had to pay.
But on that point, Mr. Watson, whereas I asked about the experience period there and dismissal, I find it difficult that an entity has certain conditions of employment and clearly set out that if you breach these, it's basis for immediate termination. And that was provided for that is provided for in your company rules. I remember when Mr. Morgan came before the PAAC, that very question was asked, such as, for example, nepotism. In the company rules, violations of these rules are basis for immediate termination. Now, against that background, Mr. Watson, you have 19 charges. I would assume that as a responsible manager, you would not have preferred those charges unless they are standing on firm ground. You would not make a charge against an employee that you can't substantiate. So you would have established that these are solid grounds. You have the evidence, you have the data to support making these charges. Is that correct?
All right. So let me remind you. Earlier I had said that one of the lessons learned out of this experience is that even our HR policies, our letters...
No. I just want to know.
I'm saying some of those things, even though we state it in the letter, according to the labor law, we cannot do it. So therefore, if you even when you have something stated, once you have a breach, you have to follow the process.
No, I'm coming there. Hold for a second. I'm coming there.
No, he's not asking that question, though, Mr. Watson. He's not asking whether you needed to follow the labor code or not. Okay. He was asking whether the 19 charges that were preferred and that were before the disciplinary tribunal were based on, were they capricious or were they based on sound?
No. We thought we had good information.
Yeah.
We looked at it, but given, and as I said, we then looked at how long it's going to take.
No, don't go ahead of me.
But yes, we thought we had a good case. That's why we laid the charges.
No, fine. Next question. In the same chronology of separation with the HR manager document that was tabled yesterday, your legal advisor made the point about following the process. If you don't follow the process if you dismiss her without following the process, you are vulnerable. So in my mind, you set out to be obedient to Section 22 and to begin to follow the process so your charges can stand up. If your charges are solid, the evidence are there, why is it? And I made that against the background of the notation by the legal officer about the institutional costs. Yes, implication. You have a solid case. You are following the procedure as you would do with any employee who have breached company rules. You are following it. How is it that you would all of a sudden feel that legal advice outside counsel tell you a 60% charge you're going to?
Is that all of a sudden?
All of a sudden, yes. All of a sudden, yes. All of a sudden. All of a sudden. Because it was going down a path. Now they were told that, look, you have a high chance of losing. Go to negotiate. Why did you abort? Why did you abort the process of following Section 22 against the 19 charges? Given again, and I reiterate, Mr. Watson, and it's a very important notation by the legal officer, the reputational costs and the precedents that you are setting by going down that road. Why did you abort the process you were going along to enter on this course? Why?
Well, first of all, I don't consider it a precedent.
You don't consider it a precedent?
No. I think you deal with the cases on a case-by-case basis. So it's not a precedent. We were going down a road, but as I said earlier, almost every day that I went to the office, I would say, do I have any grounds to take any action? And the advice was no.
Advice from the legal outside counsel?
Both in and out, yes. No, you cannot, you must follow the legal. And
no,
that is
sorry,
a sound.
I'm not hearing.
No, I'm
Chairman.
saying
Members.
Mumbling in my ears. Yes.
Members, we're nearly going to wrap up. Just let us just conclude by allowing the questions to be answered and the ask of the questions to hear the answer.
Yes.
Please, right. If you want to discuss anything, just go outside. Yeah.
So we did look at that. We thought we had a strong case, but we also at every point along the way would be conscious of how long it's going to take, what it's going to cost. So for instance, for 2 days of hearing plus panels plus other discussions, panelists, we had spent $4.5 million in hearing costs. This includes legal panelists and all that. And we hadn't reached anywhere yet in the case. So you're talking $4.5 million, and we probably barely touched 2 of the charges. So you're talking about possibly an extended time. I don't know.
But Mr. Chairman,
that's what I'm saying.
But Mr. Chairman,
you made a business decision. You made a business
primarily.
Decision.
Yeah. Mr. Watson, what is of concern to me also is that you signed the agreement. You had the agreement in November. Approval, a settlement agreement was signed on Wednesday, November 14th, and approved on the following day. All through this process, you know, the AG was in the department and the Integrity Commission was investigating. And the actions of your general manager and your HR manager was subject of the audit report based on what came to light. You knew that a report from the AG was pending. In going to a settlement, agreeing to go to a settlement, why didn't you not consider that audited information was pending? Did you seek information from the other general department to get an indication, at the very least, when that draft report would be ready, so that you could be guided by that audit information that was being
Our advice at the time was that even if that was, whatever was in the report was, let me remember the exact wording. Just give me 1 sec.
You got the report the 16th of November.
It's striking that the settlement was signed on the 14th of November, approved by the board, apparently, and yourself, the following day, the 15th, and the first draft of the Auditor General's report was provided the next day on the 16th. That's what this chronology says.
I'm trying to remember the exact response, but we did get advice that notwithstanding what was stated in the Auditor General's report, it would have still required us to follow a process. Paragraph 9.
No, it's
no,
Mr.
just
Daly.
a same question from Fitz.
No, it's Mr. Daly next, and he's anxious. Give him a chance.
Just a quick addition.
It's in paragraph number 9 of the chronology.
Yes, we know.
It says the legal advice was that the findings of the Auditor General did not waive the obligation on the part of the company to comply with the code. So it means we would still have
allow me. The reason why I raised that, because you had 19 charges based upon your assessment of what was going on. The AG was doing an audit where the HR manager was was a subject of that audit. And given the fact that that audit is being done, and the information could either help to strengthen or weaken your position in regards to the 19 charges, why didn't you not await the AG report? And it is very striking, Mr. Watson. Hold on, Mr. Watson. It is very striking that the date of your settlement agreement was November 14th, and you sought a board approval the following day, the 15th, and the draft report from the AG was on the 16th. That means that the report from the AG department was about complete. If I were in your position, and I have 19 charges, and I wasn't, if I were in your position, when you are now about to go into a decision with 19 charges, that legal advice told you that your chances are very... Why didn't you not call the AG department and say, AG, where are you with the report, so that you can get the benefit of that detailed, audited exercise to advise you to say whether or not the 19 charges would either be bolstered or be diluted? Why didn't you not seek the information from the AG department?
But I can't respond to that. I didn't seek the advice
Mr.
of
Watson,
the AG.
Mr. Dodson.
But I am saying that even some of the 19 charges would have been similar to what the AG would have picked up in the report.
The
and
timeline.
I can only tell you the dates are
Mr.
coincidental.
Chairman, I can't hear my...
Yeah, again, members.
I
Mr.
can only say
Warmington, please, sir.
The
let us
dates
just...
are coincidental.
I can't hear the responses.
They're not able to hear what's going on because talking is...
5 questions in a row you ask and the chairman not seeing anybody else.
That they have information that we don't have about the
Dali.
I
can, and I did, and I will if I consider them. If they all relate to this, if they all relate to the same theme, Mr. Clark. Well, that is up to you. Do you have a question you wish to ask? Do you have one?
I have more than one.
What? Go ahead.
No, I won't allow him.
No, I'm allowing him. Go ahead, sir. Go ahead, sir.
Come on,
ask your question that you're burning to ask. You don't have one question to ask. You had one statement to make, you made it, and that's all your contribution was.
Member of Parliament, ask your question, please.
I'll ask one for him.
No.
I'll ask one for him.
With respect.
The member mentioned the date that the Audit General has a draft report.
Mr. Warmington,
how does he know? I didn't have that. We don't have it.
It's in the chronology. It's in the ministry paper that the Prime Minister
takes. How does he know all
takes.
these when I don't know it?
Because I read the ministry paper.
It's in the ministry paper, Mr. Jackson.
Yes, sir. Thank you, Chairman. Well, Mr. Chairman, help me, sir. I'm still being bombarded.
I'm trying, but you know, Mr. Warmington doesn't want to give you a chance.
Please, thank you, Chairman.
Give Mr. Jackson a chance to wrap up his question,
yes,
please.
So my question, why you agreed for a settlement on the 14th of November, and the next day you sought the board approval, and the draft report of the Auditor General was received, provided to the General Manager on November 14th. And I note it was provided to the General Manager. I would also like the AG to indicate when that report was submitted to Petrojam. So I want a question regarding your proceeding with, no, before. And I also just put the questions one by one. That is one question. And the other question, right now the HR manager position is vacant because you're now recruiting.
It's being advertised.
And you have an acting HR manager there now. Right?
Why did you have the first?
You indicated the urgency of having somebody in place why you sought to expedite the settlement. If you had gone the route of garden leave,
are you going to another thing?
Mr. Chairman.
1 second.
The government members are.
I'm not really sure where he's going with this.
No, I am asking the question, not you. Not you asking the question.
Well, let him ask the question. Members.
No.
Allow him to ask the question. He's trying to ask a question.
Would the report from the AG, getting the report, would that have made any difference, or how would that have affected what you would do? No, because that's where he's going.
I don't know where he's going.
That is where he's going.
I'm going.
Would you have proceeded differently?
Yeah. Mr. Watson, before you answer that question, please allow the member to ask his question and then we can move on. Mr. Jackson, please ask your question explicitly.
Thank you, Chairman. So my question to you, Mr. Watson, is
all over the place.
In your constituency.
You know, you're my constituent, you know. I represent you well.
Mr. Jackson, please do not allow yourself to be sidetracked by
my constituents.
By your constituent.
Mr. Chair. Mr. Chair.
The point is that the HR position still could not be filled as long as the person was employed.
No, I'm aware of that.
Right?
No, but we get my question.
Why did you send her on leave?
When someone is on leave, when someone is on leave for whatever reason, you have somebody acting.
That's correct.
So that the work of the office can continue.
That's correct.
So if she was to go on garden leave or any kind of leave, patio leave or what have you,
someone would be acting.
Somebody would have been acting, would have been carrying out the task because I'm aware.
Right. So the question is that the case? Would somebody have been, if you had sent the lady on garden leave, would you have appointed someone to act as HR manager in her absence?
If we had sent her off, we would have had to have somebody acting, but we would have been paying her, which means that that was a factor.
Yes.
The second thing is that if you look at point 7 from the legal advice, Mrs. Ramarak was not sent on leave because the Ministry of Finance disciplinary policy provides that under no circumstance should an employee be sent on vacation leave pending the outcome of an investigation or inquiry. If it is necessary that the employee be removed from the organization to facilitate the conduct of the investigation, then the employee should be interdicted or suspended. Interdicted with pay. The legal advice was that interdiction or suspension could be viewed as the imposition of a penalty prior to a ruling being issued by the disciplinary panel. So you'd have gone to a conclusion already. The advice was that this could give rise to a successful claim at the IDT for procedural breach. Also, that her presence did not
Mr. Watson.
Mr.
Time at the Ministry of Finance.
It's after 1 o'clock now. How many?
Just 2 more questions. Two short questions.
Hold on, Mr. Chairman, please remember,
yes,
Jackson, just remember, there's an ex-committee coming at 2.
Yes.
And they need to prepare the room for tomorrow. So it needs to cut it short and stop irrelevance.
Yes. Mr. Watson, interdiction is a regular practice in the public service. Not unusual or irregular for members of staff to be interdicted and partial pay, half pay, quarter pay, or full pay. It is a normal exercise. So that advice is questionable. My other 2 quick questions, Chairman, for now. The CFO that is on garden leave, you have somebody working in their position now?
Yes.
So you're paying the CFO while he's on garden leave, and you're paying somebody somebody else to perform the duty.
That's correct.
No. The charge against the former HR manager for hiring her brother, is that brother still employed to Petrojam?
He's still there. We're going through a process. We cannot just terminate like that, and we're going through a process which I wouldn't want to discuss.
So technician.
All right.
And finally, Chairman, all the board members are party to the decision of the board, including the Venezuelan directors.
The local board members were part of the decision, but then we took it to a board meeting and advised the Venezuelans.
So you took the board decision without the external, the Venezuelans?
At the time, that's correct.
So they weren't part of that decision initially?
No, but they were advised.
All right. Member Daly?
That needs clarification.
No,
that statement,
Let her clarify.
Are you saying that the board actually approved and signed off without the Venezuelans?
The local board.
And they signed off?
Yeah, on that settlement.
So, and that is accepted as board approval? Or would you have had to get acceptance from the full board, inclusive of the Venezuelans, for it to be board acceptance?
Well, the matter was taken to the chairman, and I know the other local board members were involved, and I know the chairman took it to the full board at a subsequent meeting.
So it was subsequently approved by the full board?
Yes.
Yeah.
Confused. The approval you got
was from the local
on which
board.
you acted was from the local board
members.
Pending ratification of the full board?
If you don't want to represent it.
I'm not.
But you said it was brought to the full board.
But it was brought to the full board. Yes.
They ratified it?
That's what you're saying. She asked for ratification.
No,
you had a problem to
he
answer.
said that initially, then he sounded like he was having second thoughts about it.
Yes.
No, they ratified it.
All right, thank you.
That's what
Member Daly, we're going to wrap. This is going to be the last question.
No, Chairman, not the last.
Thank you.
There's an unanswered question that I was asking. So.
Two quick things. I'm just reminding Mr. Watson that he supply us the request which was made earlier, which is what was the final salary used to compute the separation payment for Mrs. Ramrock?
Right, we're going to provide.
Supply that. You also indicated through the ministry paper that she was paid $2.7 million for performance incentive, and it is now a public information on a score of 47.2% out of 100. Can you supply to the committee the incentives that were paid out, performance incentives, to other members of the Petrojam staff, and what were their scores?
Sure.
Not today. I know you can't do it today. Management staff.
Over what period?
Yes.
What period?
The last period that same
17,
period.
18.
Same period that
The
Ms.
17,
Ramrock,
18.
yes.
If you could prepare a schedule, or have your staff prepare a schedule of the incentive payments that were made for the 2017-18 financial year that were paid to staff.
Okay.
Chairman, final question. Thank you. AG, Member Jackson asked a question which was not answered by your team, but which I had planned to ask. When you do your audits, do you give, and in this particular instance, did you give Petrojam an idea as to when your draft was going to get to them?
They would have asked to say when would it be ready.
Was there an indication to Petrojam as to when they would have received the draft of the audit? No. The Parliament is asking a question that is related to this particular.
Yes, Adrian,
Yeah, Mr. Chairman, I can confirm that the cover letter for the report is dated November 15, 2018. And it is not unusual for entities to be forewarned of an impending draft. That's the more.
All right, thank you for that reply. Members, can we... It's 1:08. They have to prepare for a joint select committee meeting at 2. Would somebody care to move for the adjournment? Thank you. Seconded.
Did we set the date
Just a
of the
minute.
next meeting?
Just a minute,
The next
Chairman.
meeting has not yet been set.
We have not touched this, Chairman. Can we ensure...
Yeah. What date can we...
No date, you see. The Petrojam report from it, we have not touched that as yet. Huh?
Remember you had a document with a yellow clip.
Can we meet during
This is yours. This. Just let me know what I owe you so I can send it.
Is there anything else you could offer there that
I don't know. I have to give. I had one of these for you. Oh, I didn't take anything. then I wouldn't bother.